Good evening, everyone. Thank you so much for coming down here in person. We're being joined by some people online as well for this hybrid seminar. Welcome to our webinar as well, and welcome to our session on asylum law on the Brink, the UK-France Treaty and Inadmissible Claims. And that leads us straight on to our session today, and we have an expert panel of people who've all been in the leading cases on the leading case on the injunction regime surrounding the new treaty and people being removed to France. And each one is going to speak for 15 minutes on their topic, and then we will have plenty of time for questions at the end. We're all feeling our way in this area, and so practice points are no doubt going to be keenly discussed. Our first speaker is going to be Sonali Naik, KC, on my right, who is Joint Head of Garden Court Chambers and has been leading the test cases in this area. Sonali, of course, needs no further introduction because she's a leading silk in public law cases and in all aspects of immigration and asylum law. We're then going to hear from Gordon Lee, who's on my first time he'll be described as well on my far right. Very topical, isn't it, as we get past his conference. But Gordon's a leading practitioner in public law and immigration and asylum as well, and has been working in this on these cases as well. And then we're going to hear on my left from Georgie Rea, who's also been working in these cases and practices in housing, immigration, and community care and education law. And then finally from Emma Fitzsimmons, who's on my right, who is a public law barrister specialising in immigration, trafficking, community care, civil liberties and detention. So I'm going to hand over now to Sonali, who's going to give you an overview of the latest developments and then on the battle for interim relief and on the questions that need to be addressed in that area.
Okay, thanks very much, Adrian. So I'm actually going to go to the first slide, which is the next one. Thank you. The introduction, and we're going to be talked through the provisions of the treaty, how it works and how the policy is operating, and also practical tips and so on. So I just wanted to say the overarching thing about the treaty is it's new. So nobody really knows how it's going to be operated in practice. There's aspirational ambition in the treaty, and what we have sought to argue in the cases we've had so far is that the ambit and the lawful operation of the treaty are subject to the supervision of the court. That's nothing new, it's a new arrangement. So from my perspective, one would have expected the cases to go slowly, to allow them to present their arguments and then let the court adjudicate upon the questions that are in, the questions that are out, and not have things to go at breakneck speed. Well, that was an aspiration that we thought was going to happen, and I was proved entirely wrong. So that led the claimants that I'm going to talk about today, which were the two cases we've been doing, CTK and briefly SKG, to be rushed into the hurdle of a very urgent interim relief application. And just again at the outset, what we were trying to emphasise to the court is, again, it's nothing new. The usual principles apply. Serious issues to be tried, we'll identify if there are. What's the balance of convenience? How does it lie? The usual modified American asylum principles. That was all we were asking for in the cases that we have been arguing. And there was no need, in my view, for these cases to be fought, so hard fought with significant numbers of silks and juniors on the part of the government, which then meant that we had to similarly match up to engage more barristers and throw a lot of legal resources at the cases. So now I'll talk you through what's happened, but effectively now many other people, I think, have had injunctions being given on the papers, or rather more removals deferred in light of the sort of slightly unclear picture about what is going on. But that's not to say that it will stay like that. We're at a very embryonic stage of these types of cases, that's all I'll say. So if I can just go to the next slide, thank you, Sophie. You're like the community presenter. What we started on with was CTK. And just, it's important to know what the history of the case was. It was an application for judicial review and an urgent application for interim relief lodged on the 16th of September, and the court listed it for urgent relief on that day. He was due to be removed, I think, the next day, or even that night, I can't quite remember now. So it was a case that was taken on at short notice by the solicitors, and as you can see from that mini chronology on the slide, the Secretary of State, so the claim was lodged, say, about 10:30 or 11 in the morning. The Secretary of State decided to serve a decision to reject the fresh claim submissions at 2:30 that afternoon. And then we went to court at 4 o'clock. But we knew, we pleaded the case out, but we knew that we were awaiting a reasonable grounds decision. So we knew that was outstanding, and we thought, well, it's a bit strange that we haven't had the decision. Removal's tomorrow, we're going to court. Ordinarily, you would expect there to be a deferral, just for a short period. It doesn't mean that the decision will be challengeable, it doesn't mean that there'll be proper grounds to do so, but we expected there to be a deferral. Halfway through the hearing, so this is this is more than halfway through the hearing, at about 6 o'clock, so we're 2 hours into the hearing. The decision came through, the negative reasonable grounds decision. And of course, for those of you who are trafficking experts, and I don't claim to be one, but I've learned a lot about it in great detail, that it included the obvious point that there is a statement at the end of the decision letter which says you are entitled to make a request for reconsideration of this decision. And that was the point that we raised at that to the judge at that point, which is, well, we want to make that application. That those are our instructions, having had very little time with the client prior to the issue of judicial review. And then the competent authority said that they would not be able to accept such a request from France, or they wouldn't normally, I think was technically the language. So on the basis of that, the judge then agreed there was a serious issue to be tried as to whether, in fact, the removal decision was lawful when there was further investigation into the trafficking claim that could be pursued through the reconsideration process, which is actually set down in the statutory guidance under the Modern Slavery Act. So that's absolutely critical. And because it was the first time that seemingly that the Secretary of State had engaged with her or turned her mind to this argument, her immediate response, as you now know, was the day after she decided to change the policy and say that there would not be any more reconsiderations. And we will come to that question in a moment. But for these purposes, that was where we were, and that was the basis of the injunction that was granted. I'll just go to the next slide. Thank you. Of course, the serious issue to be tried isn't the only consideration for the judge. The judge has to consider the balance of convenience, unsurprisingly. And because of the nature of the decision, and because of the timing of the decision, and because of the remedy, which ordinarily would be operated in country, i.e. reconsideration, we thought to persuade the judge, and he agreed, that there should be an interim order to suspend the claimant's removal for 14 days. So it's not a blanket interim relief. It wasn't even interim relief generally, liberty to apply. It was, again, what I've been doing many years in my practice, have done with many urgent removals, is that you ask the court to hold the ring while everybody can go away and think about what the legal arguments are and respond to a decision they've had for more than 20 minutes. So that was the way in which we presented it to the court. And we also then said the solicitors would provide their their best endeavours to get the further evidence and make representations within 14 days, which they did. And that was the position as we were, and when we left court. The next day the policy changed. The day after that, I think after hours, the Secretary of State decided to lodge an appeal to the Court of Appeal. Can I just go to the next slide? Thank you. Thanks. So her grounds of appeal effectively were that there was no serious issue to be tried on Article 4. There was an effective remedy by way of judicial review, which is out of country in France. Balance of convenience, that he got the factors wrong, including the public interest in the timely removal of the respondent CTK, that the period of relief granted was excessive, and that also the Secretary of State sought, notwithstanding that this is an appeal against an interim order, sought to admit fresh evidence in the appeal by way of the witness statement that wasn't before the judge when he made the decision. All of that was quite surprising to hear from our point of view, given the way that the issues had come out before Mr. Justice Sheldon, as it was, he made the order, and the way in which the decision had arrived, and the point about reconsideration and no, and that it couldn't be heard from France. And in addition, it was just, again, the narrow nature of the order that we had sought, the holding the ring order, was what genuinely we thought was surprising when it came to hearing the Secretary of State's grounds of appeal. So just move on to the next slide. Our response to the appeal was, well, the court, considering the appeal against the grant of a decision to grant or refuse interim relief, can only set that aside if it's the exercise, if the judge's discretion was based on a misunderstanding of the law or the evidence before him, or where the decision is so aberrant, that no reasonable judge could have made it in the common terms. That was the principle that Lord Justice Singh applied in the PCSU. That's the first Rwanda case, if you like. Indeed, that case the government relied on before Sheldon. So in any event, we say none of the grounds apply in this case, and we also refer to the recent Court of Appeal decision in the Amori case, which is Palestine Action, about when you can and can't have urgent interim relief, and also what the threshold is for the test if you're trying to appeal the decision of the judge below. And so I'll just go to the next slide if we can, thank you. Just in principle, I think it's important, because when we come to more practicalities, we'll see about the principles about interim relief, but there's no elevated threshold in public law cases. It's just, again, serious issue to be tried, and what is the context? Can the significant weight be attached at the balance of convenience stage, the fact that there's a general public interest in allowing a public body to exercise its powers in what it considers to be a lawful manner? In this case, particularly, the Secretary of State had made the decision and said you've got the right for it to be reconsidered. It was, legitimate expectation basis that's how the decision was framed, notwithstanding the policy being changed subsequently. And they tried to argue in the Court of Appeal that it wasn't necessarily the case that there would be such that it was implicit, or that you would get the reconsideration within the UK. And then fourth, we say that the balance of convenience in an interim order, what I called it was an interim. It was a very narrow order, which was a temporary ban of removal. And that was why we say that, looking at the public interest, resetting removal directions for him with a further period of notice may come in due course, but that doesn't mean that this decision of Mr. Justice Sheldon was wrong. So I'll just go to the next slide. We also emphasise that there is a public interest in due process, i.e. that things should be done properly. Back to what I was saying at the outset, why should this have gone at breakneck speed? And it was particularly breakneck for all of us, I think all of us who were in the case here, because we were just working flat out for 72 hours straight to get into the Court of Appeal on Tuesday after the hearing had been the previous Tuesday. And indeed, the government said, oh yeah, we want to hear it on Friday. We want it within 3 days of the order. Well, actually, no, we actually probably all parties would benefit from having some time to prepare it properly. I guess back to the point about defer to the exercise of discretion on the point I made about Lord Justice Singh. And again, even in the context of public law challenges, the precautionary principle set out in American Fundament applies, and it's deserving weight. And you can see that how it's been applied, again, more recently in the Epping Hotels case. And the final question is whether there's a risk of injustice, maintaining the status quo. That's all we're asking for. These are the basic principles that probably many of you are familiar with in many types of judicial review claim. Hold the ring, status quo, we'll come back when everyone's had even a couple of days to prepare and look at it. So Then just if we go to the next slide, there was a hearing on the 23rd of September. The Court of Appeal, it was listed for a rolled up hearing with the appeal to follow. And after about 4 hours of hearing from the Secretary of State, they concluded that they would refuse permission to appeal. And so that was the end of their appeal. Judgment to follow. In fact, it's now been listed, it's in the list for tomorrow. For the reasons hand down, although we have the order. I mean, we have the oral order that was given at court. And now the case is going to be, there's a return date next week for further interim relief as things stand. I just contrast that with another case that came up, which is so if you just go to SKG, next slide, sorry, which was heard, it was unfortunate for SKG that it was heard the same week, that it was the same sort of counsel solicitors team, probably on both sides, same judge. But his case was at a different procedural stage. So again, application for urgent interim relief, just recently instructed his solicitors. And he had a negative reasonable ground decision, but he was waiting for his recon decision, but he hadn't had much time to put it in with his new solicitors, I should emphasise. He had had the decision for some weeks, but he hadn't had time with his new solicitors to put in any evidence. He hadn't really had any, apart from seeing some lawyers in the advice surgery, he hadn't had anyone on record. So, until shortly before the removal. So, the court again listed the matter for an urgent interim relief hearing. They, on the same day, they decided to maintain removal to France, and just before the hearing, so an hour before the hearing, we got a decision from the competent authority saying there would be a negative reconsideration, and a witness statement from the Secretary of State in the appeal of CTK, which wasn't even in this case, that sounded to us. And it was all given us 1 hour before the hearing. So the judge expected us to be able to respond to that. We had a 4-hour hearing that finished at 8 o'clock. And finally, he refused interim relief primarily because we couldn't show any evidence in response to the witness statement, which we'd only had, well, actually, that wasn't, I don't think, served in advance. I think we got it, we did just get it 1 hour before. But of course, we didn't have the evidence in response. And again, still, access to justice and fairness, which should have required that at least there was a deferral of 24 hours or a couple of days, but on the basis of the material he had before him, and also because the claimant was at a different procedural stage because he'd had a negative RG and this was the negative recon, that the court declined to grant interim relief. So. And in fact, that case, I think it's not going to pursue or go forward. So that just shows you that there, depending on what evidence you have, what your facts are, where you are procedurally, whether you've had decent advice at the outset, and that is absolutely what all these cases are about, that will affect the merits of your any potential judicial review. So if we just go to the final slide and my final minute. Which is what I've called about the way forward, and we're going to hear more, I think, next about this from Georgie, I think, and Gordon. Obviously, the policy was changed, as we've identified. I mean, subject to the lawfulness of that policy change, and that feeds into what role it plays in modern slavery guidance, the statutory guidance, and the whole identification process of victims of trafficking. Just leave that to one side for the moment, because that's probably more than we can cover today. Just on a practical level, we need to identify what the substance of the negative reasonable grounds decision has been, what the grounds for reconsideration might be, what further evidence is required, because obviously this is a preliminary, the RG stage is a preliminary stage, as I think Emma will come on to talk about. Identify the limitations, if there are, of judicial review from France, and also recognising that you're not normally, as pointed out in the Court of Appeal by Lord Justice Lewis, how is a judicial review a remedy? Because you're not really ordinarily going to be putting in new evidence in a judicial review. I mean, kind of basic public law principles. So access to justice and legal advice prior to any consideration of the reasonable grounds, negative reasonable grounds and evidence is key. And looking at the timing of when the decision was served, whether to invite a recon, and maybe if you had a particularly strong case, whether even if you haven't got a right to reconsideration under the policy, whether you should ask for that on a discretionary basis in any event, that given that the purpose of the process is to give identification at the early stage, but it's only ever a preliminary assessment, which I think Emma is going to come on to talk about. So those are my observations about that. And unfortunately, I don't think I mentioned at the outset that I can't stay for the rest of the seminar. I've got another commitment. So I'm really happy to take any questions just on this now, if anybody wants to ask anything about tactics or what happened. I mean, I think it'll be clearer when you read the judgment from the Court of Appeal tomorrow. So I hope so, yes. But in any event, particularly CTK is in a narrow procedural context because he is a pre-policy case, pre-policy change case, whereas those people who are looking to the future will be in the post-policy scenario. So that's really where we're at the moment. So, sorry, I'm not looking at actually whether to close my laptop to see if there are any questions online. I'll let somebody else answer those. Anyway, you have Gordon was in the Court of Appeal, Emma was in the Court of Appeal, and Georgie was in the Court of Appeal. So if anyone does have any questions, they can ask them for those, any sort of tips or responses. But so again, embryonic early days, let's see what happens next. And yeah, I think that's watch this space is all I can say. So thank you. And I'm so sorry I have to, but the timing didn't work well for me. Thank you.
Thank you very much. So we will await the judgment tomorrow with interest. So we're going to move straight on to Gordon, so we've had the overarching test case point, and now we're going to see a case study of how this works in an individual case as well. Gordon's going to take us through what a case within the framework of what's going on in the Court of Appeal looks like at a first instance, I think.
Yeah, so having been brought into the case of CTK at the Court of Appeal stage, as Sonali said, with essentially 72 hours to pull everything together, I was sitting down today and I thought I'd talk to you about what lessons we've learned so far in terms of this scheme. And one of the principal lessons that I've learned is that you can get quite a lot done in 72 hours. As long as you don't expect to sleep, and as long as you just stay just this side of caffeine poisoning. So it was, as you can imagine, quite an intense 3 days as we were preparing, and it was, I have to say, Sonali did an amazing job of bringing together a team of barristers, which is always a bit like herding cats, because although we pretend we're really good in teams, we chose this job is that we're not. So what I thought would be helpful is to take you through essentially a fictitious case study from the moment someone arrives in the UK on a small boat from France. I say it's fictitious, obviously I've borrowed from the number of cases that we have looked at over the last few weeks. And the sorts of things I've highlighted are I think, the things that do come up quite regularly. So I'll talk you through that, and then I'll look at some of the potential options that someone in that position might have in terms of judicial remedies and other potential remedies. I want to just echo something Sonali said, which of course we're right at the start of all of this. So we're still getting a feel for judicial attitudes, different arguments, Home Office attitudes to the sorts of things that will make them defer removal directions, and the sorts of tactical choices that are in the best interest of clients at various stages. And we are literally learning as we go as to what works and what doesn't. But with that caveat, I'm just going to go through an example timeline. So Mr. A arrives in the UK on the 20th of August from France via a small boat. He's travelled through Europe from Libya. Typically, screening interviews are held straight away, so people are often exhausted, understandably, unrepresented, and are asked a series of questions about their experiences, their journey, straight away. So there are some obvious problems with that. Mr. Rea states in his interview that he was street homeless in France and he was subject to threats from traffickers whilst he was there. On the 22nd of August, he's issued with a notice of intent which warns him that the Home Office considers that he may be subject to removal to France and that therefore his asylum claim may be inadmissible. And he's given 7 days to make representations. In this example, he hasn't secured representation, and so he doesn't make any representations. So on the 30th of August, he receives a decision, an official decision, a formal decision, declaring that his asylum claim in the UK is inadmissible on the basis that he'll be returned to France. I think my colleagues will come on to this later, but in terms of the admissibility test, there are 2 stages. And in this example, we're going to imagine that the Home Office has applied stage 1, which says that whether or not it's credible, the reasons that he gave for not claiming asylum in France, whether they're credible or not, we're going to imagine that he's fallen that first hurdle, and the Home Office rejected his account of why he didn't claim asylum in France. Something I just want to highlight here is that we're finding that if somebody says something about the conditions that they faced in France, so for example, I was homeless, or I don't want to go back to France because I've got nowhere to live, or I don't want to go back to France because I've got no access to medical assistance. The Home Office are treating that as an implicit or explicit human rights claim, irrespective of the fact that someone's not represented, irrespective of the fact that they probably don't know that they're making a human rights claim and they probably don't intend to make a human rights claim. But the Home Office, quite often, with the initial decision declaring the asylum claim inadmissible, they're also certifying an implicit human rights claim based on what was said in the screening interview. Now that has certain procedural implications, which I'll come on to. But Mr. Rea, he instructs good solicitors on the 2nd of September. Sort of in the right slide. Sorry, I should have said next slide. Yeah, thank you. He instructs good solicitors, they make representations to the Secretary of State regarding trafficking markers that they have identified on the basis of initial instructions. And on the 6th of September, we're going to imagine that the healthcare team in the detention centre does what they ought to. He gets a Rule 35 report from healthcare, which identifies that he has mental health difficulties, that those mental health difficulties are exacerbated by his detention, and that there are concerns that he may have been a victim of torture. On the 8th, he referred into the NRM by the Secretary of State. On the 10th of September, the Secretary of State makes a Rule 35 response, so a response to the medical report, where she accepts that he is a level 3 adult risk, i.e. the very highest level of vulnerability within detention, but maintains detention on the basis that removal can be set immediately and there are no barriers to that removal. On the 12th of September, there is a negative reasonable grounds decision, and then there are representations made again by the solicitors on the 14th, human rights grounds, on the basis of his risk in France because of his vulnerability and background conditions. And on the 16th of September, those human rights representations are refused with the, sorry, next slide, I'm going to be one beat behind this all the way through, I can tell, sorry. And on 16th of September, those human rights representations are refused by the Secretary of State, not on the basis that there is a certified claim, but on the basis that there's already been a certified human rights claim, and they're applying paragraph 353 of the immigration rules to that claim. So, faced with that scenario, what can you do? Thank you for the hint. Next slide, please. So, in this scenario, the reasonable grounds decision predates the change in policy, which Sonali mentioned. So, I think it was the 17th of September, wholly in response to what happened the day before in court in the case of CTK, the Home Office amended the guidance for modern slavery to exclude from the reconsideration process those individuals who would be, it was proposed to return to an ECAT, signatory to the ECAT, which obviously takes in France and pretty much every European country. So that was explicitly, I think, and also, I think, admittedly, they said that they were doing this essentially to shut off the barrier to removal in these cases. But in Mr. Rea's case, his decision predates the 17th of September. So under the modern slavery guidance version 4.1, which was the one that was in place at the time, he has a right to a reconsideration within 30 days of the negative reasonable grounds decision. As well as that, in the admissibility guidance, it says that once someone's in the NRM process, normally the transfer, or the admissibility transfer process should be paused. So there was a very strong argument, and it was an argument that during the course of the hearing from the Court of Appeal seemed to find favour, which is that an unincorporated international treaty between the UK and France cannot trump somebody's common law rights derived out of statutory guidance and the right to reconsideration of a trafficking claim. So that led to the injunction that Sheldon J issued and the upholding of his decision by the Court of Appeal. So, decision before the 17th of September, very strong ground to argue there's a barrier to removal in terms of the right to reconsideration. Obviously, as time moves on, that cohort of people that can say that they fall within that category is going to get smaller and smaller. Sorry, next slide. If the negative reasonable ground decision postdates the 17th of September, personally, I think there is an argument that the change in the guidance it certainly wasn't changed after a long period of reflection and consultation and consideration about the effect it would have on somebody's rights, Article 4 rights, etc. So we're early days, but I think the consensus is there is an argument that the change in the policy per se is unlawful, and potentially in an individual case, as Sonali said, could be a strong argument that shutting someone off from reconsideration is unlawful. That obviously will play out. There is obviously, in either scenario, the potential to ask a court for a stay on removal in order to pursue those particular rights. Next slide. So, leaving trafficking to one side, in our Mr. Rea's scenario, you have a very, and this is I think typical, a very early inadmissibility decision. So they make the inadmissibility decision as quickly as possible. And then what tends to happen is that evidence is obtained. Now, in his case, we have strong evidence in the form of Rule 35 report, which says that he's vulnerable, that he has mental health difficulties and has been a victim of torture. Now, all of that is potentially relevant to the stage 1 test in the admissibility decision. So the question of whether or not he's been credible, and also whether or not it's credible that he would be under the control of traffickers and so forth. So it's clear that in those circumstances, the defendant ought to review the inadmissible decision based on the evidence that comes particularly from their own healthcare. Second point is that is France a safe country for the individual, Mr. A, in the circumstances of his individual vulnerability? And third, should a final decision on admissibility and transfer await the end of the NRM process? Just to help everyone, I've answered that question. Yes, it probably should. Whether it would or not is obviously a matter for the court. So those are the sorts of things one ought to be looking for in terms of the inadmissibility decision itself. Next slide. In respect to the human rights decision, I think in principle, treating someone's answers in a screening interview when they don't think they're making a human rights claim, they don't have any representation, and they've just come off a harrowing journey, is on its face unfair. The unfairness arises when they do get representatives who make coherent human rights arguments, and rather than looking at them afresh, they apply a fresh claim, paragraph 353 test. Now, the time this evening won't allow us to get into any detail about the difference between, for example, a clearly unfounded certificate and a paragraph 353 decision. But it seems to me that it's clear there is an argument to be had, that the process is unfair, and that what they're treating as a human rights claim either isn't, or at least they shouldn't be applying the paragraph 353 process at the end. So that's obviously that again, that will play out, but that's something I think that ought to be looked at. The second, and as part of the case before the Administrative Court and the Court of Appeal, a huge amount of evidence has been gathered about what precisely the position is in France, because the agreement itself has no guarantees with regard to accommodation or access to medical treatment. Nothing in the text of the agreement that says this is what's going to happen for the returnees. And there is significant evidence from NGOs and other organisations, and indeed the courts, that the French provision of accommodation to asylum seekers is inadequate, and that's probably understating it. And so where you have a claimant like Mr. A, who has documented vulnerabilities, there is, albeit a very high threshold, there is an argument that he would be at risk of critically ill treatment as a result of destitution in France. I think to be realistic about it, you would have to have someone with inherent vulnerabilities to make that argument. It's very difficult to make it otherwise. And then thirdly, should a final decision on human rights await the end of the NRM process? Again, spoiler. Yeah. Okay, finally, last slide, please. So underpinning all of this is obviously a very strong motivation on the part of the Secretary of State to detain people and to return them as quickly. Someone like Mr. A, who is a level 3 adult risk, and again, I haven't got enough time to sort of really delve into adult risk policy, but a level 3 adult risk can only be detained if there's a public protection issue. That's highly unlikely in these sorts of cases, because essentially the treaty, the agreement, excludes most people who pose a public protection risk from the treaty itself, so it's unlikely to happen. The alternative is where removal can be set essentially immediately, and there are no barriers to removal. So all of the arguments about the reconsideration application and challenges to certification in inadmissibility, all of those things are very arguably barriers to removal. So my approach, certainly in the last couple of cases, has been to lodge these sorts of claims on these sorts of facts in the administrative court, so that a claim for unlawful detention can run alongside the various challenges to the immigration decisions, and to seek both a declaration that the detention is unlawful, but also damages as well for that unlawful detention. So last slide. Do you say anything? Okay. No, it doesn't. Thank you very much.
Thank you very much for all that. So we're going to move straight on to Georgie is going to talk to us about aspects of the UK-France agreement.
Thank you so much. So the one in, one out UK-France agreement on the prevention of dangerous journeys purportedly has as its primary aim the prevention of death in the Channel. But behind the language of urgency and deterrent lies a treaty that erodes fundamental rights, undermines access to justice, and casts international and domestic legal safeguards as a procedural inconvenience for this government. The system is, we would argue, deliberately, well, we, the royal we, is deliberately construed to block scrutiny, fast-track removals, and circumvent due process in the name of deterrence. So this is an agreement, as Gordon pointed out, that binds the UK and France under international law only, and crucially, it has no force in domestic law, and individuals affected don't have domestic legal remedies unless the government chooses to grant one, or unless they rely on our existing legal framework. And this was emphasised by the Court of Appeal in CTK. Next slide, please. So the very act of ratifying this treaty alone set the tone. It was passed using section 21(1) of the Constitutional Reform and Governance Act. So the treaty was ratified on the 6th of August 2025, one day after signature, and bypassing parliamentary scrutiny. But urgency is not an excuse for dismantling accountability. And if the treaty had faced proper scrutiny, it may not have survived in its present form. And by excluding parliamentary oversight, ministers effectively said, we don't trust democracy to agree with what we think this treaty should do. Next slide, please. The treaty is underpinned by some core assumptions, which through the bypassing of Parliament haven't been scrutinised. So firstly, it assumes the inherent criminality of crossing the Channel. We have seen the passage of section 40 of NABA, and that section criminalising the Channel crossing hasn't been tested in principle, but it relies heavily on that assumption, and the first recital of the treaty mentions this concept of criminality. So it's disingenuous to then say, oh, but also we're saving lives. It relies heavily on this presumption of criminality. Secondly, it assumes that France will always be safe, ignoring clear evidence, as Gordon pointed out, of destitution, lack of accommodation, and risk of chain refoulement under the Dublin III procedure when someone is removed to France. Thirdly, it assumes that victims of trafficking will be protected, and this is a point that the Secretary of State, the Council for the Secretary of State, really tried to hammer home in the Court of Appeal, saying that as France is a Tier 1 signatory to ECAT, it will be safe and victims of trafficking will have protection. But the courts, and I've cited there AA Sudan, have found that France's protections do fall below the standards we expect here and are therefore wholly inadequate. And these assumptions are the foundations upon which the injustice of the treaty is built. So next slide, please. And the purpose of the treaty is efficient readmission and reciprocal admission, which really means speed over substance. And that's why these cases are being dealt with at breakneck speed and why we aren't sleeping for 72 hours. The UK has to return people within 3 months of their arrival and has to keep the numbers balanced, so the number of returns to France and admissions to the UK. The UK only has 14 days to identify, assess and submit a case for removal to France. France then has 14 days to respond, which can only be extended to 28 days in exceptional circumstances. And these truncated timeframes mean that by design, there can be no meaningful investigation of trafficking, no time to verify age and age disputes, I'll touch on that more later, and no chance to properly assess evidence once it is provided to the Home Office. And really, it's designed to undermine due process in order to act as a deterrent, and that's really what came through in the submissions that were being made in the Court of Appeal. Next slide, please. So Article 3 of the treaty defines who qualifies for removal. That's anyone arriving by small boat, even if they're rescued at sea and don't make it to the UK. However, unlike with the Rwanda policy, not everyone who has arrived since the treaty was in force has been issued with a notice of intent. We saw the mass issuing of those notices of intent, but here there seems to be some picking and choosing. So we've got Group A, who are detained and given a notice of removal to France, and Group B, who aren't selected for removal. And the Secretary of State has not issued a policy explaining this differential treatment or explaining how they're picking people. So therefore, it either amounts to a completely arbitrary selection process or unjustified discrimination between those two groups, because there's no policy explaining it, and complete lack of transparency there. Next slide, please. Yes, so to send someone to France, the UK must give an undertaking to France that the person has no pending human rights claim, no suspensive judicial remedy, and no injunction. Those are just three of the requirements, but I'm going to focus on those here. So what happens, and how is the UK able to tell France, we promise that none of those things are present? Well, they're going to rush through the decisions and make sure that none of them are present. And that's why we found that the Home Office is certifying human rights claims as clearly unfounded, when for all intents and purposes, a human rights claim hasn't yet been made. At the same time, this rushing of decision-making to try and get rid of outstanding claims and suspensive remedies is leading to arguably unlawful negative reasonable grounds decisions in trafficking claims, reject now and maybe assess later on reconsideration, because that avoids the statutory protection under Section 61 of NABA that means that somebody can't be removed pending if they've got a positive reasonable grounds decision, because that protection is 30 days. And if you're in the 30-day territory, it's very likely that the UK won't be able to meet the 3-month period of exchange with France. Next slide, please. I think Gordon said that we wouldn't have time to touch on the difference between the test for clearly unfounded and a fresh claim, but I'm going to try really quickly. So for a human rights claim to be a human rights claim, it needs to have all the elements outlined in Section 113 of the NIA 2002. As Gordon highlighted, screening interviews take place almost immediately after the applicant arrives in the UK, when they are inevitably exhausted, often haven't been given a chance to even sleep, and they don't have representation. So very rarely in a screening interview alone will an applicant have the opportunity to properly articulate facts that could constitute an existing or prospective breach of a protected right, not least when the questions are geared towards the asylum claim, which might be a completely different matter altogether. But yet, when the Home Office is issuing these inadmissibility decisions before substantive interviews, because they think that you fulfill the first criteria, the inadmissibility decision is also including a certification of an implicit human rights claim. Next slide, please. So that means that when people later articulate their claim, when legal representatives have had the time to get all the evidence together, these claims are dismissed as fresh claims. The bar for certification is clearly unfounded. So they're saying that whatever you said at your screening interview, that was clearly unfounded. And that is a legally higher test than the test for a fresh claim. And so that makes it almost impossible to reopen the question of your human rights claim. So I've got there a quote from Lord Phillips in ZC Kosovo that said, "A claim that has no realistic prospect of success may not be so hopeless as to be deemed clearly unfounded and should therefore attract a right of appeal." So if we did this the right way round, the human rights claim should attract a right of appeal, but because we've already had the clearly unfounded stamp put on it, even with the additional evidence and representations that are gathered later, it can't be reopened. And that's by design, because if you reopened the human rights claim, then the UK wouldn't be able to give the undertaking to France under Article 4 that there's no outstanding human rights claim, and they've missed the deadline, and it was a waste of time ever serving that person a notice of intent. So that's why the Secretary of State has kind of collapsed these two tests together. Next slide, please. So the treaty says that unaccompanied minors are exempt from transfer, and this seems like a great safeguard, but we know that the Home Office frequently misages children as adults, and challenges to age disputes aren't suspensive. Unless you are successfully granted an injunction in proceedings relating to an age dispute, you can be removed before your case is even heard under the statute. The inadmissibility guidance tries to deal with this, but it actually incentivizes the Home Office to make significantly over 18 findings, which are based solely on physical appearance and demeanour, again, which we know are notoriously poor indicators of age. Because if the Home Office says, well, actually, you're significantly over 18, then under the guidance, there's no barrier to removal either, and judicial review won't be inherently suspensive. So by relying more heavily on a significantly over 18 decision, the Home Office will still be able to deport a putative minor despite the safeguard in the treaty, which then becomes completely illusory and might as well not be there. That's what I have to say on that. Next slide, please. So we've looked at this change in the statutory guidance for victims of trafficking, but before the 17th of September, victims could request reconsideration of a negative trafficking decision within 30 days. That was a common law right, which the government had a duty to uphold in individual cases unless there was a contemporaneous articulation of a very good reason for departing from the statutory guidance, and there wasn't in our case. But as Sonali noted, as a result of the way that matters unfolded in CTK, on the 17th of September, the Home Office changed the guidance. So after the 17th of September, you don't get reconsideration if you're being sent to an ECAT signatory country, such as France. So in other words, the people who are most at risk of exploitation are now excluded from the right to ask for their case to be reviewed whilst they're still in the UK. Next slide, please. Yeah, okay, great. So the treaty also makes provision for when, if a court later finds that your initial transfer was unlawful, you can come back to the UK by court order. But by that point, the damage is, of course, already done, because Article 3 CHR breaches aren't theoretical. They happen the moment someone is exposed to degrading conditions, and you can't unbreach that right, even if you then bring them back to the UK. So in practical terms, someone may have already been refound to another country, either into Dublin and then onwards, or gone missing due to destitution, which is almost inevitable in France with the lack of accommodation, or they've been processed by France, their asylum claim has been refused and they've been deported. So in any of these scenarios, how the UK proposes to find the person and effect the order to bring them back is beyond me. Next slide, please. So Article 10 allows the UK to remove people even while judicial review is pending. So the remedy that is now proposed against a negative reasonable grounds decision is a judicial review rather than a recon. And it's said that you will be able to conduct such proceedings from France, more than likely from street homelessness in France. So unless a last minute injunction is granted. So there's a token reference in the wording of the treaty itself to giving evidence from France, but there's no published policy by the French government. And all they've indicated so far is that there might be one video suite available somewhere in Paris, which can be booked for final hearings only. So there's no mention of support, no mention of funding for legal access or interpreters, and no practical means really of participation. And it's unclear if this video suite would be available for conferences, or meetings with psychiatric experts or any of the other wealth of professionals that we have involved in these cases. So whilst you can technically participate in proceedings, it seems unlikely that a client living in destitution will be able to properly maintain contact with their legal representatives. And that's assuming they even had them before they were deported anyway. Next slide, please. I think this is my last one. I'm going to briefly look at the flip side of the treaty. So that's the one in to the UK, this new safe and legal route, which is actually less of a golden ticket and a bit more, is a bit of a mirage, because eligibility for that route depends on nationality, ID documents, and frankly luck. So people with claims, so under the guidance sets out how they're going to assess these applications, as well as there being a new appendix in the immigration rules. But how applicants are chosen means that claims with proportionally lower success rates, so for example, LGBT claims, or people who don't have their ID document or a national ID document, such as Eritreans famously, are likely to be completely excluded from the route because they just won't make it into the category of people that will be considered. And we're looking at small numbers of people that are going to be accepted on this route because it will be proportionate to however many people we deport. Even if you are admitted under this route, the entry visa only lasts 3 months. There's no right to work, no study, and no access to public funds. A person's asylum claim, I don't know if anyone's actually come in yet, have they?
They have.
Have they?
About 3, I think.
Well, I think that their asylum claim, essentially, if Section 8 is applied to their asylum claim, then it is essentially kind of doomed from the start. And why wouldn't the Home Office apply Section 8? Because this is inevitably someone who has spent a significant period of time in France, because they have to have done in order to have been eligible to apply for the route. How will Section 8 affect credibility and interplay with that? Because if the reason they were waiting in France was because they were waiting to apply for this route, won't the Home Office just turn around and say, well, Section 8 says you should have applied there, so you can't be credible? And if the visa is only 3 months anyway, how much time does that give to investigate? Who knows? Anyway. So it's not really a viable option for many people, is the flip side of it. Final slide, please. Thank you. But I'm going to hand over to Emma, who will be giving you practical tips on gathering evidence and procedure when challenging these deportations. The legal challenges have been described as last minute by the media, and have felt last minute when we're scrambling together. But the truncated timeframes set by the treaty mean that there is inevitable cutting of corners in processing applications, identifying trafficking, assessing age, and this will inevitably lead to unlawful decisions, which you have very little time to challenge. And with that urgency in mind, I will hand over to Emma.
Thanks, Georgie. We can move to the next slide. So, I mean, when I was thinking about what we might usefully say about this, if we could just move to the next slide, thanks. Is it all change, or are we back to where we've always been? I think it's probably more of the latter. We have a new framework we need to get our head around, but I don't think the challenges are that different to what we've dealt with before under Rwanda, and in general, what was Dublin 3, and more generally, very urgent removal. So with that in mind, I thought what might be helpful is to try and think about 5 things that might be useful to bear in mind when we're preparing these cases, given that, as everybody stressed, we're at the very beginning of this process, and no doubt the learning will emerge in the next couple of months. So with that in mind, if we can move to the next slide, I thought what was useful as a starting point was to remind ourselves that it's not just claimant lawyers who will be carefully reviewing these cases. I had a discussion with somebody who knows counsel, who works for the Secretary of State, and they're also doing the same triage that we are. So the cases that are being selected for removal are being reviewed very carefully. So that's something to bear in mind, because there's an interest more generally in getting these decisions right. There's a treaty that's been adopted by the UK. In principle, it may be the case that transfer to another ECHR country may not be problematic, provided that all the processes are followed and the safeguards are followed and the right people are being effectively transferred. So it's relevant, I think, for us just to bear in mind there's a broader interest in the government getting this right if this is supposed to be their flagship policy for deterring unsafe removals. And it's also, I think, important, given how divisive this issue is, to recenter it in the orthodox context of rule of law, which is something that Sonali, I think, alluded to at the beginning of the presentation. So just to bear in mind as we're going through, GLD should be also thinking about the judge on their shoulder. Obviously, that's what we do all the time when we're preparing these applications. So if I can move to the next slide then. The first tip, which you've all done already, gold stars, A+, is to try and get familiar with the legal policy framework. Hopefully we've done something about that tonight. But just to flag, obviously, my colleagues have went through this in some detail. You have the treaty that Georgie spoke about, and Articles 3 and 4 are probably the most relevant when you're looking at whether your client falls in the cohort. Then you have the various statutory provisions. You've got Schedule 3, you have sections 80, B and C, and you have the immigration rules. The combination of those effectively is there is an irrebuttable presumption that France is a safe country for the purposes of your asylum claim. There's a rebuttable presumption that it's a safe country for the purposes of your human rights claim. So in practice, Secretary of State is very likely to say the asylum claim is inadmissible, very likely to say that the human rights claim will be certified. And the immigration rules also say that if asylum is being treated as inadmissible, any humanitarian protection ground would as well. In addition to that, you have 2 important policies to flag amongst all of the kind of general policies to be aware of, but there's the inadmissibility guidance, and also there's the CPIN on France, which is something that I'm going to come to talk on a little bit, but is something that will generally have to be, I think, forensically taken apart in order to start building the evidence base as to why we say there are gaps with things like refugee recognition rates for specific cohorts, why there may be problems with accommodation, why there may be problems with protections for trafficking victims as well. So that's tip 1, and then if we can move to the next slide, please. Tip 2, always what I write at the top of each page, what is my case before I go into court? Because I think it's quite difficult when you're working in a really urgent context with a highly vulnerable client who has been served with a decision to remove and a decision to not admit their claim, to actually unpick, well, what practically as a lawyer can I achieve, and where can I put this case into the legal and policy framework? So in preparing for this, I looked at the treaty and I also looked at the inadmissibility guidance, and what I could see, I mean, this is likely to change and it's probably going to grow as the learning develops, as it did with Rwanda, but I thought there were about 5 broad categories of case that might arise. So the first is where you've got a dispute about whether the connection criteria are actually met, and Gordon talked about how in policy Secretary of State applies a 2-stage process to whether or not it's credible that the client could not claim asylum in France or another safe third country. I think that's something that it's not to be overlooked, because my experience from the Rwanda cohort was that there were in fact reasonable and arguable cases to be made about the criteria being applied. And in particular, just to flag, for example, I had clients who had undiagnosed learning difficulties who did not understand that they should be seeking asylum in a safe third country. They were under control of agents. They had been given particular instructions. They had no access to an independent lawyer. And so in those circumstances, it was not reasonable to expect them to have made a claim for asylum. So those are the kinds of things to flag. And obviously, everybody's already alert to the fact that people who are under the control of traffickers may well not have been able to make any kind of claim en route to the UK. The second category is obviously what the policy allows for is this discretionary basis to put forward against inadmissibility, and that's in likelihood going to be linked to the cases where you bring a human rights claim. So for all of the reasons that are well known in terms of Articles 3, you've got your medical cases, you have your material deprivation and destitution cases in France. You have risk of onward refoulement if your client is going to be Dublined and there is a real particular risk that the other country may not have a high rate of refugee recognition. These are all obviously difficult questions for you to be working out in an urgent context. So one other thing I would stress is if you can start allocating resources now to preparing these sorts of arguments because they're not easy to identify. And then the last two categories of case, I thought George touched on these. You've in the inadmissibility guidance and the treaty itself. So obviously EU nationals are out because they've got a different regime. You have US who should be protected, age doubted, but treated as children for the purposes of assessing age guidance. And that's the problem that Georgie identified. It's the children who are not being doubted, but who are pushed out of that guidance as well. And then finally, the guidance itself identifies cases where they can't reasonably make a decision in a reasonable period. And that's where the trafficking cases bite, because the reality is the NRM should take priority over that. And we all know that that process, in any case, is delayed, and you're very likely to have a huge gap between RG and CG. So those are the kind of broad examples I could think of that might be relevant kind of frameworks for thinking about individual clients. And then if we can move to the next slide, please. The third thing then to think about is your gathering evidence strategy. So things that might be relevant in terms of taking instructions. I think it's important in these cases to probably focus on the fact that they need to be run as individual cases. It's going to be very hard to get, I think, any kind of generic relief on systemic grounds given where we are with France, but it is possible if you are looking at your client's individual case and their facts need to be thoroughly investigated. I had a quick look at the statistics in terms of what nationalities are likely to arrive by small boat, and the University of Oxford's Migration Observatory helpfully says that, so for the last 5 years or so, the nationalities are Iranian, Afghan, Iraqi, Albanian, Syrian and Eritrean. So everybody understands what that cohort looks like anyway from their day-to-day protection work. That's a helpful tool for unlocking what the protection needs of those clients are likely to be, and also where the risks are going to be. So if there are risks around journey, for example, going through Libya, that might be a relevant factor that's flushed out by their nationality. If there are risks in terms of not having access to family support remittances and therefore at greater risk of things like destitution in allegedly safe third countries, those things are also going to be relevant as well. So with that in mind, not to be all doom and gloom, but obviously the instruction taking process is going to be really challenging with these clients, given that they will have been detained. Very often they will not have had access to high quality legal advice at the outset of their detention, where most of the decision making is taking place. You may find yourself instructed later down the line, finding that nothing's been done, but decisions have been made. It's also the case, I think, often very junior fee earners are having to take these instructions in difficult situations because people are detained, there's a need for interpreters. So it's important that we try and support each other as best we can in light of a new policy challenge down the line, because these are difficult cases to assess and also to put forward. I think some of the key flashpoints for instruction taking are likely to be underlying reasons for seeking protection and whether that presents any protection risks with respect to France or Dublin. I had a quick look at what kind of recognition rates France has for those nationalities through the EU Agency for Asylum. And it's quite a mixed picture in terms of their recognition rates. So you can see Syria, for example, 81% recognition rate, Afghan 67, Eritrean 56, Iraq 40. But then there are other nationalities that drop away out to 20, 10 and less. So it will obviously be bespoke. There are some nationalities that will be properly protected, but you may find you have a particular client who's not going to be adequately protected. Everybody so far has obviously alluded to the fact that the journey is going to be a critical point for instructions. So it's important to be familiar with the trafficking and modern slavery indicators and statutory guidance. And also to just remind yourselves that obviously these clients are very unlikely to self-identify or self-disclose. That's not necessarily their fault. It's part to do with the structure of the question and the screening interview. It's also part to do with expecting lay people to understand difficult legal concepts like exploitation. So those shouldn't necessarily be treated with caution if they are late instructions nonetheless. I would say try and be a detective about what the connection to a safe third country is. Try and build your case as much as possible as to what the conditions were like. If they've been through France, where were they staying? What kind of material support, if any, did they have? What were the limitations of that? What was the treatment by the French authorities? I know from the Rwanda cases we had, there was certain nationalities faced a lot of discrimination and sometimes police brutality in the camps from French authorities. Things like that need to be flushed out if possible in instructions. Hidden vulnerabilities as well, that brings in the effectiveness of detention safeguards. Is there a Rule 34? Is there a Rule 35? Are they being properly screened for any kind of hidden vulnerability? Have the Home Office linked up with healthcare and with detention safeguarding measures like the gatekeeper when they're passing the instructions over to the third country unit? And then finally, access to legal advice. I mean, I think it's particularly if you're finding yourself as the second or third rep on record, it's important to work out, well, what happened before? What is the chronology? Did the client have any proper advice before? Do I need to get the file from the previous list, or do I need to put on record that there were problems with that? Because a point that will come out in the CTK case is, which both Sonali and Gordon have alluded to, is that sometimes people aren't having reps put in pre-decision, which means when a firm is instructed later down the line, then you're into more difficult territory because you're in a different framework, you're maybe past certification, you're into fresh claim, but then everything's also treated with suspicion as well by the Home Office. So we can move to the next slide then. Also have a think about, I mean, I think this is for generally all of us across these cases. What is the evidential case I need to answer? And this is obviously a huge piece of work that's going to take lots of thinking and potentially instruction of experts. But there is a CPIN that is quite lengthy. I think it's 79 pages. Yeah. And it's going to take a sizable piece of work to do a proper analysis of that. It's obviously the kind of work that would be worth doing without the pressure of removal directions. So if it's possible to start that work now, if it's possible to allocate resources to looking at how reliable is the analysis, where are the gaps? Two things that are already flagged that are likely to be real problems, it's the accommodation, material support, and the trafficking support as well. The accommodation section in the CPIN itself even highlights that there have been two fairly recent ECHR judgments about France's response to applications for accommodation for asylum seekers. That's a bit of a mixed picture in the sense that one case has been effectively managed by the Committee of Ministers, one is still outstanding. But clearly, you know from your day-to-day practice that there are anecdotally people who sleep in tents, who sleep in camps, who are reliant on charitable donations to just have basic things like food. So there are clearly gaps, and that needs to be ironed out well. And then if we can move to the next slide. Yep, so just the usual things to think about. Everybody's very familiar with that. So I would just say keep all those avenues open, and then if we can move on to the next slide. Yeah, I think these are just tips about just make sure you've got all the records and be aware that the decision making is going to be disparate, that you will have records that are relevant from detention records and then relevant records that are held by the third country unit, and you need to kind of plot through to see if possible, has the Home Office properly looked at all of the different bits of information before they have made a decision. The next slide. Which brings us to how to influence decision making. So if possible, I think the best thing to do is try and front load these cases as much as possible because they are likely to become urgent. And these are exactly the kind of cases where judges are looking at the representations that were made to the Secretary of State. So what is being put on paper is being very closely reviewed by the judges when it comes to whether or not they should grant interim relief. And then I think the final thing, my final tip, which is just to remember procedural rigor just generally because these are difficult cases. You know, basic things, what jurisdiction are you in? Do I need to be in the High Court or is the UT sufficient? Make sure you follow the procedure rules because these are going to be sensitive and difficult cases in any event, and temperatures I think generally are a bit higher, I would say, given where we are. And then also, you know, just good practice where possible. Try and get in hours where you can, try and be prompt, make sure you notify the other side. And if you do have to go out of hours, then obviously try and make sure that the court is properly decided on all that and it's lined up, because then that obviously puts you in better stead with the judge as well. So those are my 5 tips. Good luck.
Thank you very, very much indeed. Thank you to everybody who has given a presentation. I had to run through very quickly those last few tips, but the slides will be available, and so they're all there for you to look at. I just wanted to leave some time for questions because we're all working our way and feeling our way through this. So if people want to, I haven't got access to whether there are online questions in front of me, but in the room, who would like to ask a question? Yes, sorry, your hand was raised, but not so high.
Actually kind of maybe getting a point on the out, but I was really interested on the brief section on the ins, typically to do with the visa or the entry clearance that's granted to individuals that arrive here legally. From my previous experience of individuals coming legally outside the rules of asylum, a lot of them have been granted recourse to public funds because you can't make a Section 95 application out of country, so presumption is that we execute on arrival. I wonder, does that limit the sorts of people that would be able to effectively arrive here? Because
Yeah, I think we'd have to be. I can check the guidance whilst we're here, but we think, yeah, they probably have access to the immigration belt accommodation, but I will have a look now.
Anyone else want to come in, or should we?
I know quite a lot about the outs. I don't know very much about the ins and the rest.
Okay, does anyone else have a question they'd like to ask?
To answer questions, you just need to open the Q&A box.
Right. Was there another question there?
Yeah,
Yes,
I've got a procedural question.
Yes,
I don't know
yes,
if that
okay.
can be assisted. When we're doing an urgent application, I know there's a guidance that we can go to and see where we're going, but if I'm filing an urgent application out of hours, is there a particular guidance or like the judicial rules online where I can go and be like, okay, that's the number I need to call on, or here's what I need to do to file an urgent injunction?
So are you talking about you can't lodge in hours and it's after 4:30? And
Yeah.
Okay. I mean, I would start with the admin court guide that's just come out for 2025, but effectively it's got a summary there of the out of hours jurisdiction.
Okay.
The things you need to be aware of are that it's a really, you have to be really careful about whether it's warranted to go out of hours or not. There's special obligations that apply to all lawyers that use the out of hours jurisdiction. You want to familiarise yourself with the cases there, in particular the case of Hamid, which is about the abuse of those jurisdictions and what can happen if you don't follow the best guidance. But in short, what you do is you follow the guidance in the admin court guide, which directs you to phone security at the ACO. They will alert the out of hours clerk that there is an application for out of hours relief. Usually the clerk will then be in contact with you. Separately, there's an out of hours form that you can find online that is a different kind of application form that you can complete. If you can, I think it's good to give the judge proper grounds when you're going out of hours and not just rely on what's on the application, because the more argued it is, the more you flagged up where the gaps are in terms of your disclosure and what you've not seen, the more you've protected yourself as a representative. And then effectively you'll be asked by the clerk to provide that application to the court. If the judge needs to hear from you, he or she will call you then, will call counsel and to do the application. It's probably outside the scope of today, but I mean, I think generally we've done training before on this jurisdiction, but we can probably direct to that.
I think it's useful, I mean, to remind ourselves about that. And one tip is always take a note of what you say to the judge as well from record, just in case. You can't overshare with a judge on the phone after hours. So really, and a lot of the high-need jurisdiction where people have got into trouble is where corners have been cut to the point where it seemed that the other side's case has not been put, or crucial bits of information or evidence have not been drawn to the judge's attention. So a kind of confessional approach to the application is your insurance effectively, but also gives you the comfort to know that when you do have to make the point about lack of disclosure, or holding the ring while the matter's considered, you need a temporary stay, then the judge has the confidence in your, it's more persuasive, you see, as well. So it's not just a procedural thing. So
just a couple of points on that. We've noticed in these cases that the court's very, very keen on input from the Secretary of State. So I think CTK the hearing finished in the evening, didn't it?
Was that right?
Oh, yeah.
So the full court like at 7 PM or something. The other thing is, excitingly, the Court of Appeal also have an out of hours jurisdiction. And I can recommend, if you want to feel alert on a Sunday night, on the phone to the Court of Appeal at 8 PM. That definitely sets the week up nicely.
scaling the summit of advocacy at that point. Do you have another question? Yes.
Also, I think someone called Wasim was wanting to ask a question from the online group. I don't know if he's still there, but I just wondered if there are any NGOs that are working in France across the border in collaboration to kind of help the people who return, like Care for Calais or
Understood. I didn't know if either of you knew the answer.
Well, yeah, there definitely are. We have had, so in the course of gathering evidence about conditions, we've had contact with solicitors, have had contact with organisations on the ground that speak to firstly what the actual practical situation is, but also what the kind of judicial remedies there might be in individual cases. So off the top of my head, it's Utopia.
That's right.
56.
56, was getting the number wrong. Utopia 56. I forget the other organisation off the top of my head, but there's at least two. But that's from the perspective of what we've been involved in. That's been on an evidential basis. That's to try and get the information. I'm not sure there's been. I mean, I suspect the solicitors are better placed than we are to know that, but certainly there is an attempt to build up an evidential picture of what somebody faces from the moment they arrive in France through and access to courts and so forth. And we built up a reasonable evidential basis for that now.
I that Medicine Sans Frontières was really good for the deaf.
Okay, that's it.
Question at the back.
Hi, I have three questions.
Excellent.
So much has been really helpful and interesting. The first question is about the change to the modern slavery statutory guidance. Would you suggest capping the negative reasonable grounds decision and the our assumption that they're going to follow their policy and refuse a reconsideration, or do you think it's worth requesting a reconsideration and seeing what comes back before papping the refusal to reconsider? That's one question. Secondly,
Speaking personally, a bit easier to hold one question at a time in my head.
Yeah.
So can we answer them one at a time?
Yeah.
Because by the time you get to number 3, number 1 will be a distant memory.
Yeah.
So maybe it might be worth getting everyone's input. I think it depends on an individual basis. I think it's always easier to present to a court a non-theoretical position. So if you're in court, it's better to say, well, we tested this, we tried this, and they followed their guidance. And then you can then attack the guidance itself. You can attack the absence of a use of discretion in an individual case, and you can go from both ends. A lot of it obviously will depend on timing, because you might not have time to do that, you might have to go off straight away. But I think from my perspective, in an ideal world, you're better off challenging an actual refusal than saying, if we do this, this will happen.
So my second question follows on from that, from your answer. That is how we've been approaching it. We've been after testing reconsideration and saying in our refund request, like, we acknowledge the change to your guidance, but we think it's wrong anyway, and we think we should reconsider. And our experience has been that they have been agreeing to reconsider, and in my most recent case that I've dealt with this on, they've actually made positive use of the ground. But you know, this is a client who exactly falls within what the policy change was supposed to catch for the government. And I feel like, having seen this happen as a bit of a pattern now, obviously it's very early days, I wonder if they're deliberately not letting us get to the stage that we can challenge it. So I wanted to sort of survey the experience in the room and see if other practitioners are seeing them just sort of back away from their new 14.216 and actually make reconsideration decisions, even though they could apply their new policy.
Well, we could take a quick straw poll. See, hands up if you've come across that. Okay, well. I mean,
I wouldn't be surprised if that was it.
Yeah.
You've got good back.
Have people seen the inverse of that? So requesting reconsideration, but instead of, and then the Secretary of State refusing in reliance on the new policy?
hands up if you've seen that.
Time.
I mean, obviously we don't know how representative this is. I mean, so if there was going to be a challenge to policy per se, I think it would probably be helpful in those circumstances to have either an intervener or an interested party and bring it as a kind of strategic litigation challenge, I think. I think the difficulty, I mean, I totally understand what you're saying, but the policy is pretty unambiguous. When it says sorry, you don't have this.
But there are loads of things that we can argue about the new paragraph. I mean, the fact is that it applies to people who the government is intending to remove. How long is a piece of string? How long is that going to take? Is this person supposed to wait for 6 months, a year, while the government intends to, but hasn't even yet made a formal decision to remove them to that country where they're supposedly going to have access to their Article 4 right? So, I mean, there's so many things that are wrong with it.
I think that it's the classic kind of tension that you come up against, whereas in your individual clients' cases, it's obviously works really well just to ask for reconsideration. But at the same time, you've got the back of your mind that there's
lots of unrepresented people who don't have that.
Whereas they might just be picking people who have
We are in our reconsideration request obviously setting out what is substantively wrong with the RG decision. So we're able to say that there is an underlying basis on which you have to reconsider or give us access to some remedy to this decision.
I think it would have to be either a particular set of circumstances or as part of a broader sort of strategic challenge in circumstances where it was in the best interest of the client to go straight at the policy rather than apply for recon.
And another question connected to 14.216. Do you think that it's the France UK returns cases that are best lent to a strategic challenge to it? So obviously Albanian clients are also affected, but they would be being removed to their home country, not as third country nationals to.
It's a really good point, actually.
Yeah.
It's a really good point.
So we've got a few Albanian clients that we're like weighing up, who
So
are already affected by it.
I'm trying to remember the exact word in the paragraph. It simply says signatory to ECAT. Doesn't
That's
it?
how you see it, John.
It doesn't say anything about tiers, does it?
No.
Tier 1, tier 2. So, I mean, like if you're going to pick a challenge, obviously France being tier 1, it probably would work better to go after a tier 2 or tier 3 country. So yeah, I think the short answer is probably yeah.
And then my other question, my third, I know I got derailed.
Sorry,
My third question is much smaller. For the client, I'm sorry, I've forgotten the initials, SKG, the one on the 18th of October who was refused interim relief, and others who have been refused interim relief and removed. Are you or others that you know of pursuing JRs for those people from our country?
I think that depends on what, I mean, I don't know about all the cases, but I think it depends on whether people are still instructed effectively. There's no, if you've got contact with your client, there's no reason why you shouldn't be able to say that. And they've given you instructions to do it.
Article 9, facilitates it
Yeah.
effectively.
Yeah, I think it's more likely that maybe if something goes wrong and maybe, there's an interesting practice point there, I think, about making sure that if when you're dealing with these cases, making sure your retainer also maybe covers to act in their best interest in the event that they are in fact removed in this period of losing contact, etc. If you've got like a really slam dunk public law challenge, you're confident the RG wrong, but you know that these people can go missing, right, when they get to France.
So is that what's happened with the client that Sonali was speaking about?
I think we don't know.
So then when you're not still instructed?
I'm not involved in that case anyway.
Thank you very much. And we're slightly running out of time, so I think we'll have to draw matters to a close. I'd like to thank all our speakers, Sonali, who had to go to another engagement. So thank you all very much. We can thank our speakers in the usual way. Thank you all very much for coming.